Subscribe for more. The Laken Riley Act, January 29, 2025. Overview. Public Law 119-1, titled the Laken Riley Act, amends the Immigration and Nationality Act, INA, to require the detention of certain non-citizens, aliens, charged with theft-related offenses. The law also enhances state enforcement authority by allowing state attorneys general to sue federal agencies for failure to detain or remove non-citizens in violation of immigration laws. Section 2. Mandatory detention of certain non-citizens charged with theft. This section modifies Section 236CE of the Immigration and Nationality Act, INA, 8 U.S.C. 1226C, which governs the detention of non-citizens convicted of certain crimes. Key changes expands mandatory detention for non-citizens charged with theft crimes, adds burglary, theft, larceny, shoplifting, and assault of a law enforcement officer to the list of offenses requiring mandatory detention, includes any crime resulting in death or serious bodily injury, applies not only to convictions, but also to individuals who are charged, arrested, or who admit to committing such offenses, defines key terms, defines burglary, theft, larceny, shoplifting, and serious bodily injury according to the laws of the jurisdiction where the act occurred, requires Immigration and Customs Enforcement, ICE, to issue detainers. The Secretary of Homeland Security must issue a detainer for non-citizens fitting the new criteria. If the individual is not already detained, ICE must immediately take them into custody. Section 3. State Enforcement Authority. This section expands state authority to challenge the federal government's enforcement of immigration laws by amending Sections 235B, 236, 243, 212D5, and 241A2 of the INA. Key provisions. State attorneys general can sue the federal government for failing to enforce detention and removal requirements. State attorneys general, or another authorized state officer, can file lawsuits against the Secretary of Homeland Security for failing to detain or remove non-citizens under Sections 235, 236, or 241 of the Immigration and Nationality Act. Injunctive relief can be sought in federal district courts to compel the federal government to enforce immigration laws. Expedited court proceedings for immigration enforcement lawsuits. Federal courts must prioritize and expedite cases brought by state attorneys general to enforce immigration laws. States can sue for financial harm. A state or its residents are presumed harmed if they incur financial losses exceeding $100 due to the federal government's failure to enforce immigration laws. Limitation on judicial injunctions against immigration enforcement. Amends 8 U.S.C. 1252F to ensure that certain lawsuits filed by states challenging immigration detention failures are not subject to general injunction limits. Section 4. Expansion of state authority over immigration parole. This section modifies Section 212D5 of the Immigration and Nationality Act, 8 U.S.C. 1182D5, which governs the parole of non-citizens into the U.S. Key changes: states can challenge federal parole decisions. If the federal government grants parole outside of urgent humanitarian reasons or public benefit considerations, state attorneys general can sue to overturn the decision. Expedited court proceedings. Any lawsuit challenging improper parole decisions must be fast-tracked in federal court. Section 5. Detention of non-citizens during removal proceedings. This section amends Section 241A2 of the Immigration and Nationality Act, 8 U.S.C. 1231A2, to reinforce mandatory detention policies. Key provisions. Expands mandatory detention during the removal period. Ensures that non-citizens must be detained while awaiting removal if they fall under the new categories defined in Section 2. State attorneys general can sue for violations. If ICE fails to detain non-citizens as required, state attorneys general can sue in federal court. The court must expedite these cases. Section 6. Federal real property use and disposition. Ensures that the federal government accurately tracks real property used for immigration detention purposes. Requires federal agencies to assess whether excess real property can be repurposed for detention operations. Legislative history. Introduced as S5, H.R. 29. Considered and passed in the Senate, January 13th to 17th, 20th, 2025. Passed in the House on January 22, 2025. Signed into law by the President on January 29, 2025. Published in the Daily Compilation of Presidential Documents. Overall summary: the Laken Riley Act, Public Law 119-1, significantly strengthens immigration enforcement by mandating the detention of non-citizens charged with theft-related crimes and expanding state authority to sue the federal government for failing to enforce immigration laws. Key takeaways: expands mandatory detention. Non-citizens charged with or convicted of theft, burglary, shoplifting, assault on a law enforcement officer, or crimes causing death or serious bodily injury must be detained by ICE. Strengthens immigration detainers. Requires ICE to issue detainers for non-citizens fitting the expanded criteria. Gives states legal standing to enforce immigration laws. State attorneys general can sue the Department of Homeland Security, DHS, or Attorney General if they fail to detain or remove certain non-citizens. Courts must fast-track these cases. Allows states to challenge parole grants. If DHS grants parole outside of strict humanitarian public benefit standards, states can sue to block the decision. Increases accountability in federal immigration policies. Strengthens enforcement of detention and removal requirements. Enhances transparency and state involvement in federal immigration policy. By implementing stricter immigration detention policies and expanding state authority, this law represents a significant shift towards stronger immigration enforcement at both federal and state levels. Subscribe for more!